Good afternoon. My name is Jeff Follansbee, and I serve Chautauqua Institution as its Vice President for Advancement. It's my great pleasure to welcome you this afternoon for a discussion with Ruth Marcus of the Washington Post, who will be interviewed by John Q. Barrett. Support for this lecture is provided by the Robert H. Jackson Lectureship Fund, which has provided a Chautauqua lecture on the Supreme Court of the United States for the past 14 seasons. Interviewing Ruth Marcus today is John Q. Barrett, Professor of Law at St. John's University, where he teaches constitutional law, criminal procedure, and legal history. Professor Barrett has produced extensive scholarship on Robert H. Jackson and serves as the Elizabeth S. Linney Fellow at the Robert H. Jackson Center in Jamestown, New York. He is a graduate of Georgetown University and Harvard Law School. We now turn the program over to Professor John Q. Barrett, who will introduce Ms. Marcus.
And this year, a new way of being at Chautauqua Institution. This lectureship, the Robert H. Jackson Lecture on the Supreme Court of the United States, occurs annually around the end of the U.S. Supreme Court's term. It's an opportunity to take stock of the court's work and to hear from an expert, an insider, a real guide to what the court's work is amounting to and where it may be going. The lectureship is named after Robert H. Jackson, who was a native of the Chautauqua region. He was a Chautauquan in his youth and a Chautauqua lecturer across his adulthood. And over his years as a U.S. Supreme Court Justice, 1941 to 1954, he brought various of his colleagues to Chautauqua Institution. Thus, the Jackson Lecture sort of follows in his footsteps and continues Chautauqua's strong tradition of bringing the U.S. Supreme Court to the Chautauqua audience for examination, reflection, and informed discussion. We're very privileged that this year's Robert H. Jackson lecturer is Ruth Marcus. She is deputy editorial page editor at the Washington Post and a nationally syndicated columnist. She's a graduate of Yale College and Harvard Law School. But rather than practicing law, she began to practice journalism and has had a most distinguished career, bringing her legal skills to various positions, including covering the court as a post-Supreme Court correspondent and writing across the years about the Supreme Court. Most recently, she has published an excellent book, Supreme Ambition, Brett Kavanaugh and the Conservative Takeover, which will be one of our topics of discussion today. Ruth, welcome. And if I can begin biographically, why journalism rather than a more traditional path in the law?
First of all, thank you. Thank you to Chautauqua and the Jackson Center for having me. I wish I could be there. I know we all wish we could be there personally. And I guess there are two things when John first talked to me about this lecture, which is such an honor, which turned into a discussion because it's so hard to lecture remotely. There were two things that we didn't imagine. One was a global pandemic. And the second, which is somewhat related, is that on July 6th, the Supreme Court would not have actually finished its work for the year. But we roll with both of those punches. I knew when I went to law school that I did not want to practice law, but I wanted to go to law school. There's a famous quote from not Justice Bork, but Robert Bork, Judge Bork, at his confirmation hearings, where he was asked why he wanted to be on the Supreme Court, and he made a number of mistakes at his confirmation hearings, which I'm going to date myself by saying I covered in part. But one was that he said he thought that it would be an intellectual feast to be on the court, and I actually thought that law school was an intellectual feast, and I pretty much knew I didn't want to practice. And I knew when I went to journalism that I wanted to use my law degree, but not to be constrained by it. So I've written about a lot of things over the course of my now lengthy career beyond law, but I do love writing about law.
That's great. Well, you know that if you're ever nominated for the court, intellectual feast is a bad answer.
I will never be nominated for the court, but I have sat through enough Supreme Court confirmation hearings that I could give you a pretty good list of what not to do.
I'm sure that's right. Let's turn to Supreme Court confirmation hearing, the topic of your book, Supreme Ambition, which is the 2018 nomination and eventual confirmation and commissioning of the court's junior member, Brett Kavanaugh. Of course, when Donald Trump was elected, a big factor was the vacant Supreme Court seat, Antonin Scalia's death in 2016, President Obama's nomination of Merrick Garland, the Senate Majority Leader parking that nomination and nothing more ever happening, and then Donald Trump getting to appoint Justice Gorsuch in his first year. Then the next development is the retirement of Justice Kennedy, who had been the median justice and probably more liberal on social issues than anyone Trump was likely to appoint. Was it a surprise that Trump picked Kavanaugh?
Actually, I think that the original surprise was that Judge Kavanaugh, now Justice Kavanaugh, was not on then candidate Trump's original Supreme Court list. Trump as candidate did something that no other candidate had ever done before, which was he put out this famous list of potential Supreme Court nominees. And he put out not just one, but two. And the astonishing thing on both of those lists was the notable absence of Brett Kavanaugh, because, of course, as a judge on the D.C. Circuit, as somebody who was highly credentialed, was the right age and everything else, it was a little bit surprising that he would not have been on that leading list. But he was not there for a few reasons. He wasn't there because he was a Bushy, and Trump didn't want to be anywhere near close to anything related to anybody whose last name was Bush. And he wasn't there because he was viewed with some degree of skepticism by some of the social conservatives who the reason for Trump's list was, of course, to get social conservatives and evangelical conservatives convinced that he would be a trustworthy president if he were president and getting to fill that seat. By the time that finally on list number 3, which came out after Justice Gorsuch was confirmed in the fall of 2017, that list came out with 5 additional people, but the main point of that list was to get one name on it, and that name was Brett Kavanaugh's. So by the time that Justice Kennedy decided to retire, it was not a done deal at all, that Justice Kavanaugh would be named. And in fact, for me, my favorite part of the book is the what I call the invisible primary, which is, I think it was 12 or 13 days during which President Trump was making his decision. And there was a big behind-the-scenes campaign mounted to try to deny Brett Kavanaugh the nomination. So he was always a very likely choice for President Trump once he got on that list, but he was not the kind of fait accompli choice.
How much was the addition of him to the list an inducement for Justice Kennedy to retire, given that Kavanaugh had clerked for Justice Kennedy and they have a close relationship?
I think it was designed as the kind of comfort animal for Justice Kennedy to retire. Justice Kennedy, it's really important to understand, is a very traditional country club type Republican, but he is also a Republican, and he very much wanted to be able to leave his seat for a Republican president, even a Republican president like Trump, to fill. One of the opening scenes of my book described the fancy pants dinner in Washington, when we were still able to have fancy pants or any kind of dinners gathering, called the Alfalfa Club, where one of Justice Kennedy's sons said to Kellyanne Conway, "No one was more pleased with the election results than my father." And Kellyanne Conway responded, "Well, that's the kind of happiness that matters." So Justice Kennedy was thinking about retiring, had thought about retiring the previous year. The Trump White House came in during the transition thinking that they were going to have not just the Scalia vacancy, but a Kennedy vacancy to fill that term. So they'd get 2 within the first 6 months. So getting Brett Kavanaugh's name on that list was a very deliberate signal that was orchestrated by the White House counsel, then White House counsel Don McGahn, to get Kavanaugh's name on the list in order to provide some comfort for Justice Kennedy. In fact, Justice Kennedy, on the day that I tell this story in the book, on the day that Justice Gorsuch was sworn in, this beautiful spring day at the White House, asked for some time alone with the president. And what he's basically said to him was, look, you've got this list. There's a lot of really great names on this list, but there's a name missing. And the name he mentioned was Brett Kavanaugh's. So that was before Brett Kavanaugh's name turned up on the list. So you can imagine that that was advice that was pretty swiftly heeded.
Yes, indeed. So Judge Kavanaugh is nominated. He survives that invisible primary. And then the Senate investigative process in preparation for the public hearing occurs. And that's the long, complicated tale of the allegation by Dr. Christine Blasey Ford that when they were high school students, Brett Kavanaugh sexually assaulted her, first coming to the attention of elected officials, and then not early on coming to the attention of the Judiciary Committee. What did your reporting find about that, and how nefarious is that saga?
Well, I don't know if nefarious is the word I would use for it, but I want to go back and say one sentence about the invisible primary, just to understand how fascinating this was. A main source of the maneuvering to deny Brett Kavanaugh the nomination was the chief nominations counsel for the then chairman of the Judiciary Committee, Chuck Grassley, a guy named Mike Davis, who had actually clerked for and then Justice Gorsuch and had helped get Gorsuch through. But he thought Kavanaugh was, and this was his phrase, too swampy, too bushy, and too chiefy. In other words, too much like Chief Justice John Roberts. And so a potential squish. So he turned out to be an incredibly fierce and effective advocate for Judge Kavanaugh once he was nominated, but he did run this rogue effort to deny him the nomination.
Did he have an alternative candidate?
It was on almost anything but Kavanaugh alternative. There were a couple other people in that final list, and he just really didn't trust him. So what happened was, as Christine Blasey Ford is watching all of this happen, and she doesn't know about Mike Davis behind the scenes, of course, but she does know that Brett Kavanaugh's name is on the short list, and it's getting shorter, and he's there, and she tries to figure out how to get this information to people. And she ends up calling her local congresswoman, Anna Eshoo, and says, I have this, but she doesn't hear back right away. By the time she hears back, Kavanaugh has been nominated. Anna Eshoo talks to her, says, I promised you confidentiality. The next day, after they finally talk, which is early-ish July, Kavanaugh's nominated, I think, July 9th, and they talk several days later. Anna Eshoo calls Dianne Feinstein, who's the ranking member of the Judiciary Committee and also the senator from Christine Blasey Ford's home state, and tells her this story. And Dianne Feinstein says, that's very serious. Have her write me a letter. And another 10 days go by before that information gets transmitted to Christine Blasey Ford, who by then is in Rehoboth Beach in Delaware. She grew up in DC, and that's a normal vacation spot for those of us in DC, with her parents. And she's like busy trying to write this letter in the Walgreens parking lot and on the porch of her house, because she doesn't want her parents to know anything about this. But anyway, the letter eventually gets at the end of July to Senator Feinstein, who basically swears her one or two staffers, really one staffer who knows about this, to secrecy. And Christine Blasey Ford has said that she doesn't want anybody to know about it until she gives the go ahead, and she's really agonized about whether to come forward. And Dianne Feinstein, having been elected in the aftermath of the Clarence Thomas, Anita Hill hearings, one legacy of which is if information is out there that's derogatory to a nominee, guess what? It's going to come out. It's going to come out eventually. That's the lesson. And I watched this. I lived it in real time. That's one of the many lessons I took away from it. Dianne Feinstein doesn't go to Chuck Schumer, the minority leader. She doesn't go to the whip, Dick Durbin, the number 3 person in the Senate, and the Senate Democrats, who is also on the Judiciary Committee, to say, hey, how should we handle this? We have this explosive information, but this poor woman doesn't want to come forward. She holds on to it and holds on to it and holds on to it until, but meanwhile, half of Palo Alto knows about it, okay? It's a small community. Christine Blasey Ford, even by the time she reached Dianne Feinstein, had spoken to enough people about it that it was all but inevitable, in my judgment, that the information was going to come out. And by the time, when Christine Blasey Ford finally, on the Friday evening before the hearings are scheduled to start, reaches back to Dianne Feinstein and says, okay, I'm not going forward. I don't want to go public. That's the point at which various things started to happen and the information started to leak through various mechanisms, including, I believe, Anna Eshoo, the congresswoman who had originally promised her confidentiality, because things leak when the stakes are this high. And it was, so I don't think it was nefarious. I don't think, as Brett Kavanaugh said at those hearings that we all can't forget, that Democrats sat on it and only unleashed it deliberately at the final moment when they knew all their other mechanisms to defeat him would work. I don't think at all that's what happened. What happened was powerful information leaks eventually, and that's what happened here. Certainly people were out to get Brett Kavanaugh, no question about that. And then the whole thing came tumbling down. It was a classic course, a master course in how not to handle this, though it was very difficult to handle.
Right. So eventually, through the Washington Post and other media, the information does emerge and is addressed in the hearings that we, of course, all did watch. Dr. Blasey Ford's testimony, and then Judge Kavanaugh's return to testify in rebuttal to her allegations. Your book is deeply reported. It seems that you really talked to all the players. I understand there's confidentiality involved, but you have a full canvassing of what happened there. What do you make of it all? Who was telling the truth? Was someone not telling the truth? And what did it reveal about the fitness of the candidate?
Well, I think Christine Blasey Ford was telling the truth and has the story that is most likely to be the story as it happened. And all of the arguments, well, nobody else who was there remembers this party. Well, it was a party on a summer night a long time ago. I also think, and this may make me the world's most naive person, that when Justice Kavanaugh vehemently denies that he did this, I don't think that he's lying. I think this was one stupid drunken night in probably a summer full of stupid drunken nights. I've never had one of those myself, but I have them, and that he simply doesn't remember what he did. And then there's a question of, if she is telling an accurate story and his denial is not accurate, what would that say about his? I mean, obviously, if he was out and out consciously lying, that would be disqualifying. If I'm correct and he's not consciously lying, how would you deal with stupid things that you did in high school? I think that's a really difficult question. In an odd and unnerving way, Justice Kavanaugh gave us an out on this, at least gave me an out on it, because I didn't have to decide whether that was disqualifying in and of itself, because I thought, the Washington Post editorial board thought, and the editorials that it wrote, that his intemperate performance, his partisan performance, his anger, his disrespect at those hearings was in fact evidence of a lack of judicial temperament. So that would be where I come down on the whole matter.
Okay. So that's a nice segue from the book to the court today. The book, again, is called Supreme Ambition, newly out in paperback by Simon & Schuster.
Not quite out in paperback.
Coming soon in paperback.
Will be, yes.
But
we're waiting? Hardcover, really.
Right. Okay. So Brett Kavanaugh is confirmed by the narrowest of margins, and he is about to complete virtually 2 full years on the court. In that hearing, he said in his heated way that people who have opposed him and have been part of this process will reap the whirlwind. Has he, as a justice, been bringing the whirlwind? Is he the culmination of a political project? What do you have to say about his judging so far?
Well, he is the culmination of a political project. The book is called Supreme Ambition, Brett Kavanaugh and the Conservative Takeover. And the ambition applies both to Justice Kavanaugh's ambition to be on the court, but also the ambition of judicial conservatives to cement a conservative majority. And I know there's been a lot of consternation in conservative circles that they feel like with adding just conservative justices, they're like Lucy in the football, and the fifth vote keeps getting snatched away from them in cases that they really care about. But I do think that there is a solid conservative majority on the court. I think unhappy assertions to the contrary. Chief Justice Roberts is not Anthony Kennedy, and he's certainly not David Souter. He's not a closet liberal. He's not even a closet centrist. Justice Kavanaugh, when he talked about reaping the whirlwind, and that was, to use the word I used before, unnerving, he said very quickly afterwards that he wanted to make sure that he was the same kind of justice that he would have been had none of this horror show from his point of view ever happened. And I think that that is largely turning out to be true from the evidence that we have of the first 2 terms. If you look at Justice Thomas, who was always going to be a conservative justice, I think it's fair to say that the experience of the Anita Hill hearings left him embittered and angry, and probably pushed him even further to the right than he would have been. I don't think necessarily, I'm sorry, are you guys hearing me okay? Mm-hmm. Siri was just talking in my ear. I don't know what I did to her. I don't think that he would have. I don't think Justice Kavanaugh. He's always lived in a little bit of a different world than Justice Thomas did. He has a remarkable number of liberal friends and living in liberal Washington. He is coming out where we expected, I think, which is to the right of the Chief Justice and to the left of Justice Gorsuch, the initial nominee. I think one of the things that's fascinating over the last 2 terms, though, now that we have almost 2 terms under our belts, is that there not really been occasions where the Chief Justice has sided with the 4 liberal members of the court, where Justice Kavanaugh, where he could have chosen to, has joined him. He is definitely, if Mike Davis worried that he was too swampy, too bushy, too chiefy, I don't think he's turning out too chiefy for Mike.
Okay. So let's take a step up in seniority to Justice Gorsuch. You locate him to the right of Kavanaugh and maybe put him more or less where Justice Thomas is. Justice Gorsuch penned this incredible interpretation of the Civil Rights Act of 1964. And I don't mean incredible.
Surprising interpretation.
Surprising, but maybe literal and accurate, that because of sex, prohibits discrimination against people who are homosexuals and people who are transgendered, because there is no way to describe what an employer cares about adversely toward them without referencing their sexual identity, behavior, preference, etc. So has Neil Gorsuch turned out to be some kind of a squish or some kind of a grand disappointment to the people who put him on the list?
I don't think so at all. I think that look, if that decision is disappointing to people, they can go to Congress and ask Congress to change that decision, for one thing. For another, no justice, maybe Justice Thomas, is going to bat 100% for the conservative team and be absolutely reliable in every case, and probably not even Justice Thomas either. And if you look at Justice Gorsuch's terms, he is a conservative justice, and he used in that Title VII case, giving the protections to gay, lesbian, and transgender workers, he used a very conservative technique. And it just shows that you can use whatever technique of constitutional interpretation you use, you can end up with different results, whether it's the result that you want or just the result that you think is the one that is the most natural reading of the law. And I can completely imagine a world in which Justice Gorsuch, imagine a future Justice Gorsuch confronted with a case that asks whether the Constitution protects the right to abortion. He says, you know me, I'm a textualist. I look at the words of the statute or the words of the Constitution, and I don't see it there. So you tell me where it's there, where it says right to privacy, where it says that right to privacy includes the right to abortion. So I imagine him quoting that majority opinion that he wrote, which I was very surprised and happy to see, that the Chief Justice joined him, and using that majority opinion as a quotation to conservative outcomes that I'll be frankly less thrilled about.
Right. Let me pull on two threads you just mentioned. One is Chief Justice Roberts, who was the sixth vote in that Title VII Bostock case, and the other is the constitutional topic of abortion rights. The court also recently decided a case, June Medical, where Chief Justice Roberts was the surprising fifth vote to invalidate a Louisiana restriction on abortion availability. What is, in your view, going on with the Chief Justice and with abortion rights jurisprudence?
So those are two different topics. Let me take them in the order that you asked them. I think what's going on with the Chief Justice is not that he's gone suddenly wild, as I said before, but that he is playing a long game. He's playing a long game to do two things simultaneously: to move the court in a conservative direction, but to do that in a way that does not harm the institutional standing of the court. And, you know, there's a really interesting question about whether Chief Justice John Roberts rules differently and has a different and more restrained or more moderate jurisprudence than Justice Roberts, which he was, as people recall, he was not initially nominated to be Chief Justice. He was nominated to take Justice O'Connor's position. I think the fact of his chiefiness does lead him to make certain that the court doesn't go too far too fast. But that doesn't mean he doesn't have a direction that he wants the court to go in. And so if you think of the ways in which the Chief Justice has deviated from what conservatives might want, there are two categories of that. One category of it has been in statutory or even more often administrative procedure questions, where it's not that you can't get, for example, last term, the census case where he disallowed the citizenship question from being asked, or this term where he said, no, President Trump didn't do things the right way when he tried to revoke President Obama's Dreamers regulation. He just wants people to follow the rules and turn, as he said, square corners. Is that not a Jackson quote? Is it, John?
It's not a Jackson
quote. Yeah, sorry. Everything else is a Jackson quote. So he's given liberals a vote in situations that are either statutory, as in the Title VII case, or procedural, as in those other two cases that I mentioned, where it doesn't really change the fundamental jurisprudence. There's two constitutional cases where he's gone with the liberal side. One involves the sort of contorted way he managed to save the healthcare law, Obamacare, the Affordable Care Act, and the other is his most recent vote in the abortion case. And in both of those cases, what he has done is actually embed some conservative principles or limits in constitutional doctrine, limiting the reach of the Commerce Clause, limiting the reach of congressional spending power in the Affordable Care Act case, and ratcheting back the standard to make it more permissive, more forgiving of abortion restrictions in the future in the June Medical case. So he is playing a long conservative game. He's 65. He's going to be Chief Justice for many, many years to come. And conservatives who are upset with him right now should just settle down and keep their eye on where he's taking the ball. In terms of the abortion case, this was a big surprise. It was the first abortion restriction that the Chief Justice has ever voted to overturn. He had been in the dissent in a case that was essentially identical 4 years ago. There were ways in which he, if he wanted to, could figure out ways to come out the other way. But what he did in this case was to ratchet back, as I said, the state of the law so that while this particular restriction, which was a requirement that abortion providers have admitting privileges at local hospitals, while that was struck down in the Texas case 4 years ago, and it was struck down again in the Louisiana case, other abortion restrictions in the future will be tested only to see if they pose an undue burden on the woman's abortion right, not tested to see whether they make any sense at all, whether there's any health benefit to women as a result of that decision. He lopped that part off. So this falls very, very far short of overruling Roe, but it does make it easier for people who oppose abortion to find other state laws and get them upheld that will restrict the abortion right in practice.
Do you expect, if a case properly presents that question after this election in the next 4 years and the justices don't change, that the 5 conservative votes are 5 votes to squarely and directly overrule Roe versus Wade, or Casey as in its modern interpretation?
You know, Justice Brennan used to say that the most important rule at the Supreme Court was the rule of 5, and you needed 5 votes to do anything. I think that if you look at Justice Roberts' discussion of stare decisis, the principle that you stick by the case that was decided, and in this case, and I've talked to people on both sides of the Roe question, practitioners, they all read his opinion as being very leery of overturning Roe as in a full frontal, it's no longer the law. It's like Karamatsu, the Japanese internment decision. It's like Plessy v. Ferguson. It's gone. I started with the 5 because I think he would be particularly reluctant to do it with 5 votes. I can imagine being more willing to do it with 6. People forget that Roe was originally decided, if you can believe it, by a 7-2 vote. I do think that, so I think a 5-justice court is not going to overrule Roe, but I do think there are 5 conservative justices who will be very hard pressed to find an abortion restriction that doesn't pass their muster. The thing that's going to be really difficult for them, and that I think they're going to try to stay out of as long as they can, sort of like the way they've treated gun cases since they decided their Second Amendment case, is when they deal with things like a 6-week ban or a 10-week ban on the right to abortion, which really, it's hard to figure out how you would argue with a straight face that that's not an undue burden or substantial obstacle.
Right. The court has less than a handful of pending cases before it finishes this term. And 2 of them are the subpoena cases involving President Trump. One is the congressional subpoena, the other is the Manhattan DA's subpoena. Does Donald Trump's presidency and the way it's being conducted, and I think these subpoenas are in that ballpark, make John Roberts less conservative than he otherwise might be? And thus, is there a prospect that executive power could fail to carry the day, even in this fairly conservative court, in these Trump subpoena cases?
Well, if you put somebody like John Roberts, a square corner turner, to the test, you will see in the census case and in the DACA case that he's exasperated with the way, to some extent, with the way the Trump administration has proceeded. On the other hand, he still is a conservative. He still is a believer in executive power. He worked in the executive branch. And so you see, for example, in the travel ban case from last term, he's not going to be questioning what President Trump's motives might be in the travel ban. He's just going to look at it and say, go ahead and do it. We accept your explanation. Same thing, he actually wouldn't look under the hood of what the motivation was for DACA, even as he said that the Trump administration didn't try to revoke it the correct way. And I think you look at some other cases, for example, there was a case decided last week involving the constitutionality of the Consumer Financial Protection Bureau, where the majority on the court said in order for this to pass constitutional muster, the president has to have power to be able to remove the director at will. This has implications for the status of other independent agencies. And so even with this president, there is a move to shore up or entrench executive power. At the same time, when the president goes too far and says, no, I can't, even though you said that President Clinton could be sued in a civil lawsuit by Paula Jones, I don't have to answer a duly issued subpoena from the Manhattan District Attorney. That they may well think that that's way too far. I don't know what you think, John, but I'm somewhat predicting a split verdict in the subpoena cases. That is I can imagine a world in which they uphold the subpoena from the Manhattan DA and quash a subpoena from the House.
Yeah,
or subpoenas from the House.
I'm in agreement and picking up on turning square corners. In part, I think I can see the decision coming that says that the Congress did not properly turn the square corners in its subpoenas, whereas the DA might well have. We've touched briefly on religion, at least in the sort of political motivation for the lists and the Trump appeal to evangelical voters and so forth. These justices and a number of the decisions in the past term continue to grow the free exercise clause to have a view of conscience and religious scruple as an exemption to generally applicable laws. The court is scheduled to take a big case next term on that issue. Are we heading for that jurisprudence where religion will be an out, a lawful opt-out from the anti-discrimination laws and so forth that bind everyone else?
I think so. I mean, I think that the question of the scope of, as the court has issued decisions that I think are sitting pretty well with a majority of the population. You know, obviously abortion continues to be something that is so divisive, but for the most part, the Obergefell gay marriage ruling, I think that these recent decisions on job protections for gay, lesbian, and transgender workers, if you look at polling, people are surprised that those don't already exist and believe you shouldn't be able to be fired from your job because you're gay. I think those will sit very well with people and that the court is comfortable with it. It hasn't veered too far from where public opinion is, but the tension arises and it will constantly arise and we'll be litigating for the next 5 years or more over the scope of this, where those decisions that it has reached, which are broad decisions that have a huge impact on society writ large, how those intersect with religious freedom and where to draw those lines. So you saw after Obergefell, the gay marriage case, the Masterpiece Cake Shop case about whether the baker had to produce the custom cake for the wedding. We still don't know the total answer to that, and we're going to see this played out across the board, especially as we now have this additional Title VII protection for gay, lesbian, transgender workers. That's the sort of, I think that's going to be the fault line of the court's jurisprudence in the next several years.
Right. One final area before we turn to audience questions. I'd like to ask about the combination of pandemic and election, and what the court's role is already and what the court's role likely is going to be as people endeavor to vote in these very hard circumstances. And in some jurisdictions, the authorities won't be making it easy, and that will produce lawsuits. The court already decided a case in April about the Wisconsin primary. It had the tragic name of RNC versus DNC. And the court basically did not make it easy for absentee ballots to be counted. Is the court going to make it hard for the American people to be counted? Or is the court going to defer to politicians who are going to make it hard for all the American people to be counted this November?
I think that you see two lines of cases intersecting. You see the court's approach to questions about voting rights and restrictions on voting on the one side, and then you see all sorts of questions that are heading to the court. Justice Kavanaugh had one over the weekend about mass gatherings. Sort of pandemic litigation and voting litigation are going to coalesce this fall into all of these questions before the court. And having been sitting in the editor's chair actually the night Bush v. Gore came down, I think that is finding itself in that position is the last place that John Roberts wants to be, but it is a place where it's almost inevitable that a lot of these disputes are going to get to the court, and that it's going to be called on them. And it has not been particularly, the conservatives are not particularly willing to tell officials that they have to be open to making sure there's adequate access to voting. It's going to, and this is not healthy for the court. Mm-hmm. To find itself embroiled here and to find itself in what is inevitably going to be perceived to be a partisan role.
Right. Ruth, this has been a fantastic conversation, and I could ask many more questions. I didn't ask about the prospect of Supreme Court retirements.
I was waiting for that.
But I will defer, because I bet a Chautauquan will have that question, and I know they'll have many others. So at this point, I'll turn it back to Jeff, and I know he's fielding questions from the viewers. Thank you very much.
Thank you, John. It's so much fun to talk, even from afar.
Thanks, John. As we move into the Q&A for those joining our live audience, know that you may submit questions through the submission portal at questions.chq.org from any mobile or desktop browser, or on Twitter using the hashtag CHQ2020. Love to have you talk a little bit about what it's like to be on the other side of this now conservative majority, and how the liberal bloc in such a partisan time, which seems to have affected the court. If you look at analyses of how Republican appointed judges vote and Democratic appointed judges vote, how do you think, what's the mindset on that side of the court?
The word that comes to mind is grim, sort of resolute. I think that for the four liberal justices, this is a operation of damage control. I think you see that most particularly with Justice Kagan trying to forge some alliances and some agreements with the Chief Justice, maybe with a few others, in order to reach the result that she would like, maybe not in the way that she wants it, or to reach a result that at least limits the doctrinal harm that's caused. But Justice Brennan was right. You have to be able to count to 5. And so the 4 liberal justices were sitting there on election night in November 2016 thinking, this is going to be great. We're going to have a 5th vote. And Chief Justice Roberts was probably sitting there thinking, I'm going to be the chief in name only, and not the amazing new swing justice. But it didn't work out that way, and elections have consequences, and 2 of them are sitting on the court.
Do you think we'll ever have a Supreme Court justice confirmed by a vote approaching anywhere near 99-1?
No, no. And it's really sad. I mean, Justice Scalia, I believe, was confirmed by 98-0. Maybe I'm missing one who voted against him, but I don't think so. The days of bipartisan votes are more or less over. You can count a handful on one side or the other, and there's lots and lots of reasons for this. People like me lamented at the time, and maybe lament it even more now, the absence of the filibuster. When it comes to, first it was lower court judges, and then inevitably it happened with Gorsuch, with Supreme Court justices. There's a really interesting question, by the way, of whether if Democrats had not pressed the filibuster with Gorsuch, they would have been able to defeat Kavanaugh. And it goes like I'm sorry to keep bringing everything back to Brett Kavanaugh, but I did spend quite a bit of time thinking about him. It goes like this. If Democrats hadn't filibustered Justice Gorsuch, which would have been hard for them to do because their base really wanted to filibuster, Republicans wouldn't have gotten rid of the filibuster then. Then it would have been in place when Justice Kavanaugh came up for a vote. And the way as it unfolded, that would have come up. You would have had Susan Collins not only needing to vote to confirm Brett Kavanaugh, but needing to vote to get rid of the filibuster. And there might have been enough votes on that procedural matter that he would have needed 60, or the effort to undo the filibuster would have gone away. But in any event, we are where we are. We are in the world of party line votes. I worry about a world in which we have not simply pure party line votes, but a party in control simply refusing to confirm justices of the opposite party. Because in the aftermath of the blockade of Merrick Garland, it's hard to argue that rules are rules and people should behave appropriately and honorably. So all sorts of it is very bad to have pure party line votes for justices, but even worse things can happen.
What do you think of the idea to add seats to the Supreme Court?
Also terrible. But imagine this scenario. Imagine that there is a retirement at the end of this term, whenever the end of this term comes. Imagine there are 2 retirements. And Mitch McConnell, as he has said, will leave no vacancy behind, and he's going to confirm both of those new nominees. And so you'll have younger conservative justices on the court for a long time to come. How, in a situation where he's been so situational, where he refused to confirm Merrick Garland, but for some reason it'd be totally different to confirm a successor for Justice Thomas or Justice Alito, the 2 who I think would be most likely to retire if we did get a retirement. I fully believe that Mitch McConnell would, if he could, get somebody confirmed on January 10th, 2021. Or actually wouldn't be able to be then because the new Senate would have been sworn in, but at the last moment possible. How can you argue that you should play by the existing rules to Democrats who would be infuriated by this and say, no, they stole the Garland seat. Now they're stealing these 2 seats because they're refusing to play by the Garland rules. It'd be really hard to contain that fury if something like that were to happen.
Well, now that you've opened up the question of retirements, I'm curious as to why you think it would be either Alito or Clarence Thomas.
Well, no liberal justice is going to voluntarily leave, so I take 4 of them off the table. 2 are new; they're not going anywhere. The chief isn't going anywhere. The chief is in the most amazing position as the most powerful Chief Justice since the 1930s. He has been in the majority in every single 5-4 decision this term. He is the justice most often in the majority generally. So he's not going anywhere. But they are older, and they are looking ahead. The Supreme Court doesn't just see the election results, but Supreme Court justices see polls. They very much want to be replaced by, if they were to be replaced by a president of their own party, just as Justice Kennedy was. So they could look ahead and say, do I want 4 years of Biden if he's going to be elected? Do I want 4 years of Biden and then another 4 years that I'd have to stick out of potentially Biden's vice president running? And so that's number one. Number two is, you could imagine a world in which, look, I think it is very likely true that had it not been for Justice Scalia's death in Texas in February 2016, that Donald Trump would not have been elected president in November 2016, because that vacancy really galvanized his base to get out there and vote, especially after he assuaged them that he would be a reliable president when it came to their concerns. So you could imagine, in particular, Justice Thomas, his wife is a political activist. She's quite partisan. You could imagine a justice thinking, boy, if I'm thinking about leaving and I'm tempted to leave, this could give a little push to President Trump.
How much of Justice Kavanaugh's behavior at confirmation was to show Trump he was a fighter so the president wouldn't pull his nomination?
A little bit, but I think not quite as much as people intuited. The president was nervous about what was going on, was calling around and saying, really did not like what he thought was his milquetoast appearance on Fox News earlier in the week, wanted to see him strong, but in part, it was his ferocity. It was to galvanize the base, to help galvanize Senate support. Interestingly, Senator Collins did not like his Fox News performance and thought that somebody who had been falsely accused should show more emotion. And so he was responding to an audience of more than one, I believe.
Could you talk about the role of the Federalist Society in President Trump's approach to the Supreme Court and even lower court nominations?
I could talk about the role of the Federalist Society all day long. I mentioned Judge Bork before. Judge Bork's failed nomination, was a never again moment for the conservative movement and for the conservative legal movement. And the Federalist Society, which was just a few years old at the time, and Leonard Leo of the Federalist Society in particular, helped to create the legal, intellectual, ideological, and financial architecture, not just through the Federalist Society, but through affiliated groups and millions and millions of dollars in undisclosed donations, to make sure that they were never going to be borked again. That a couple things, that they would both grow a cadre of conservative judges, and groom them to potentially be on the court, that they would not be surprised in the way that they were surprised and terribly disappointed by David Souter, who was announced by George H.W. Bush as a home run for conservatives and turned out to vote quite often, if not always, with the liberal justices. He was a liberal justice. And so the Federalist Society's role grew over the years. It was significant in the George W. Bush administration, but particularly in the Trump administration, the role of vetting and selecting these judges, as the president himself said, was kind of either outsourced to the Federalist Society when he was running and wanted his list put together. And then, as Don McGahn said, the White House counsel, once he was elected, it was kind of insourced. And so they brought in a whole bunch of Federalist Society folks. And I think if you look at the list of Trump judges, the ones who are not members of the Federalist Society are few and far between, certainly on the appeals courts.
Can you talk a little bit about today's decision on the faithless electors? The questioner says, it seems like this is an appropriate protection against ongoing bursting of political norms before this practice actually affects an election.
So I'm going to actually have to confess here that I know the outcome of the case, but I haven't had a chance to read it yet. But I think that's a pretty good analysis, and I'm going to actually bring in John for a second, who has read the case, who has smarter things to say about it.
Am I now on?
You are on.
Okay. I did read it. It's a short opinion and incredibly powerful, written by Justice Kagan. It's a unanimous result, and it's in a tradition of court decisions going back to the 1950s, a court that Robert Jackson was on, that say the states get to legislate their vote systems, how delegates are pre-committed to the winners of the popular votes in the state, and that states get to back this up with penalties. In one case, replacing somebody who would be a faithless elector. In the other case, fining someone for so-called faithless behavior. And so I think it is, as the questioner said, a way to contain norm busting before it busts out too much. It's also a sort of a bipartisan result, because the faithless elector movement in 2016 was a couple of electors trying to start a groundswell of other Trump electors agreeing not to vote for him and to take the Electoral College away from him. And so it's a disaster that neither party's candidate would want to encounter, and I think the court lets the states prevent it.
Our next question presumes that the Merrick Garland situation and asks whether it's a damaging precedent, given what you just said.
I'm not hearing all of a sudden. I'm sorry.
I was asking about Merrick Garland. Still not hearing?
If you guys hear me, I'm having difficulty hearing.
It's asking about Merrick Garland.
I'm sorry, my audio has
John?
gone out. I'm going to
Maybe you need to
me-
switch me off and switch her back on.
try to do something here. Can you guys hear me now? I can't hear you, though. Yeah, all right, now I got you. Sorry about that, guys. Apologies.
No?
Can you hear me?
Yes.
Whoops.
Can you hear me, Ruth?
Okay, now I can hear you. I'm very, very sorry.
That's okay. The great news of technology. Our questioner suggested that perhaps the Merrick Garland situation was a damaging precedent. Given what you said about Mitch McConnell, maybe it's not a precedent at all, or at least a precedent that's going to be followed.
I think it was a damaging episode, much like Bush v. Gore was a damaging episode for the court. I think Merrick Garland's nomination and failure to even get a hearing was a damaging episode, both for the court, because I think he would have been a terrific justice, and for the Senate.
I have a question about elections and fairness in voting. What do you think the average citizen can do to further the ability of people to vote? The questioner cites a friend who had health issues in Wisconsin and was unable to vote in the primary.
I think everybody needs to make clear to their legislators, to their governors, to their secretaries of state, that it's important to do two things simultaneously to make sure that people in this moment of the pandemic who need access to absentee ballots and be able to vote by mail can get them easily, can get them early enough, can get them counted properly. Because even if you get your ballot and mail it in, there's a huge percentage, a much huger percentage of those ballots that are invalidated than regular ballots. And at the same time, as we've seen these appalling long lines at voting places, that we need people to be able to go vote safely in person, those who want to and can vote safely in person, to make sure that there are enough provisional ballots in those places. And because we're a nation on edge. We're so on edge. President Trump has not helped us get off of that edge. In fact, he's inflamed it. And an election, particularly one that looks like it's close, that might not be decided because of the prevalence of voting by mail this time around for several days, a president who is going to have the inclination, if he loses, to say that the election is rigged, is just terribly divisive for us at precisely the time that we don't need to be divided. So the more we can do in advance to prepare for elections to be conducted in as fair a way as possible, to get as many people as possible able to vote. And I guess the one thing that I left out was states need money to be able to change their electoral machinery, not literal machinery, but just the way they conduct elections in a quick way. And so they also need money from Congress in what I hope will be the next wave of pandemic-related funding.
Well, I want to extend our gratitude to our partner, the Robert H. Jackson Center in Jamestown, New York, for supporting today's program. I'd encourage you to visit their website, roberthjackson.org, for a schedule of their virtual events this summer, including a program this Thursday with the Center for Democracy and Technology. I want to thank our good friend John Q. Barrett for his leadership in putting this program together annually. I want to thank Ruth Marcus very much for spending time with us today. And Ruth, we certainly hope to find another time when we can bring you to Chautauqua and have you enjoy this wonderful environment and this very special community.
Thank you. I am looking forward to that. I'm looking forward to all the times we all get to be together instead of on Zoom or Skype or whatever the mechanism is.
Well, thanks very much.
Thank you for having me.